Exceptions to search warrant requirement. The first exception we are going to discuss is the doctrine of a search incident to arrest. By search incident to arrest, we simply mean if a police first place someone under unlawful arrest, police may search the person without a search warrant. That is what we call search incident to arrest. If a police already arrested someone, they could search the person without a warrant. That is what we mean by search incident to arrest. The court discussed this doctrine of search incident to arrest in this Chimo versus California. In this Chimo case, the defendant was a suspect in robbery of a rare coin store. So the police went to arrest him with an arrest warrant, but no search warrant. So the police, after made arrest, police asked the defendant whether they could look around in the house. And then the defendant said, no, you cannot do that. Police ignored the defendant, and then they conducted a full-scale search of the house. So as a result, they discovered these stolen coins. They actually went to the upstairs bedroom, and then they discovered these rare coins and stolen from the shop. So the issue was whether this search was justified or not. We need to understand, even though we have this doctrine of search incident to arrest, in this particular case, in this Chimo versus California, the ruling of the court was the police search was illegal. So we need to analyze why the court said the police search was illegal, even though the police first arrested the defendant and then the police conducted the search, why that search was still illegal. To understand that, we need to discuss the two justifications for search incident to arrest. We have these two justifications. One, the first justification is to protect arresting officers' safety. We know when the police officers are making arrest, and then possibly this suspect could be armed, so the suspect could take out this firearm to injure the police officer. So to protect the police officer's safety, we allow the police officer to conduct this search incident to arrest. The second justification is to prevent destruction of evidence. Suppose the defendant is arrested for drug possession. If police would not conduct a search right away, maybe we know there would be a danger of destruction of evidence. Maybe the suspect could put the drugs into his mouth, could swallow that, and or maybe could throw the evidence away. So to prevent this destruction of evidence, police could conduct this search incident to arrest. So we have these two justifications. But based on these two justifications, we have this issue as to where police can search. Because the two justifications for this search incident to arrest is to, one, protect officers' safety. Another one is to prevent destruction of evidence. The court said the area that can be searched is limited to the area within the person's immediate control. Meaning is, it is not police can search anywhere. Police may search only the area within the person's immediate control. So that would include the person's body and anywhere the person could reach. that is really because if a person would try to grab a weapon to harm the officer, or the person would try to destroy the evidence, the person could only conduct this action in the area within his own control. So within his immediate control. So that is also the area police could legally search. We do not want police to conduct this search more broader than this area. So we did say in this Chimo versus California, the ruling of the court was this police search was illegal. Why the police search was illegal? Because police went beyond this person's immediate control when they conducted the search. Where did the police search? The police went upstairs, even though the person was arrested downstairs. And then the police went upstairs in the person's bedroom, and then they found this criminal evidence. So that if the suspect was arrested downstairs, police actually went upstairs to conduct the search, that apparently went beyond the person's immediate control. So that was the reason why the court said this police search could not be justified under this search incident to arrest doctrine. Related to this search incident to arrest doctrine, we also have an issue whether we should have this search incident to citation. This issue arose in this Knowles versus Iowa. In this case, and the person was speeding, the defendant was speeding, and the police issued this citation. And after that, the police just conducted a search of the car, and then the police actually found this criminal evidence. And then, of course, the defendant challenged this police action. The defendant said, "You did not have this search warrant, and how could you search my car? That was an illegal search." And then the prosecution argued, maybe we have a doctrine that is called search incident to arrest. Maybe in this case we should also have this search incident to citation. So in this case, basically the state of Iowa asked the U.S. Supreme Court to recognize a new doctrine that is called doctrine of a search incident to citation, because in this case, police did not make an arrest. They only gave the defendant a citation. The ruling of the court in the case was, the court said, we are not going to accept this argument. We are not going to create another doctrine. We are not going to accept this doctrine of a search incident to citation. Why the court would not accept this so-called doctrine of a search incident to citation? Once again, we need to come to these two justifications of this for this search incident to arrest. We know the two justifications for this to justify this search incident to arrest are: one is for the arresting officer's safety, another one is to prevent the destruction of evidence. The court said this so-called search incident to citation could not be justified under any one of these two justifications. The court first pointed out when the officer is issuing a citation, the officer would not face the same risk as the officer is making an arrest. Because we all know, if a police would arrest someone, the person would lose his liberty, the person would be taken to the police station. So in that situation, it is possible the suspect may want to grab a weapon to resist arrest. So the risk is real in this making arrest situation. But in this citation situation, we all understand if you're speeding, please stop you, please give you this ticket, and after this citation is issued, what is going to happen next? You can go away. It is not really police going to take you anywhere. So the court said in that situation, it is much less likely the suspect or this motorist and would simply because he's going to receive a ticket and he would grab a weapon to harm the officer. The court said we cannot really say this officer in this citation situation would face the same risks as the officers are making an arrest. So the court said this search incident to citation doctrine could not be justified on this protecting officers' safety ground. Another justification is to prevent destruction of evidence. The court said this is also this search incident to citation could not be justified on this ground either, because when a person is speeding, if a police stop the person for speeding, police already have all the evidence they need as far as this speeding offense is concerned. If a police is talking about, they're talking about to prevent destruction of evidence, for that reason they want to search the car, inside the car, the court said, what kind of evidence you can find inside the vehicle, inside the car for speeding? A person is speeding. The police have this radar gun. They already locked down the car. They already know how fast the car actually is driving. And after that, if a police want to search inside the car, the court said, what evidence do you want to have in the car? Oh, what evidence of a speeding you can find inside the car? The court said none. So the court said you cannot really argue for this search incident to citation based on this danger of a destruction of evidence, because there is simply no such evidence the defendant can destroy inside his car. So based on this analysis, the court said we are not going to accept this request to create a new doctrine that is called search incident to citation. So just remember, the court did not accept this argument to create this search incident to citation doctrine.